While we're waiting, I do want to mention to everybody, Tuesdays, if you're an eState user, was it Susanna? Maybe if you mute, if you're an eState user, every Tuesday I am live at 12:30 to answer any questions. There's some professionalism hours that you get for learning about technology. I take you through a particular aspect of eState. We do that for a few minutes, and then it's open to questions we always have a good group. So please join us. It's free. Have your clerks join, and we'll get everybody up to speed as we continue with the improvements in the eState and making it better every day. So over to you, Ian.
Great, thanks. So I'm on a different unit, so hopefully the sound is gone. A couple of quick points. One is just a reminder to everyone as well that on our webpage, the Hull & Hull webpage, obviously eState has tremendous resources, but one of the things that we do is we post a solicitors and circulate a solicitor's tip every month. Susanna typically writes them. We're going to be talking a little bit about some of the solicitor tips that have been uploaded before, but it's a great resource. The other thing think about is sorry, just a second. Yes, Susanna, why don't you just rejoin? I think it might be you that's causing the noise. Is that Hallsbury's just come out, and it's an interesting resource that I was involved with editing in that, and we've just put out a new edition of that. So if you're looking for sort of a core elements of estate questions and so on, the Hallsbury resource is a good one. All right, so Jordy and I then can start while Susanna's trying to get back in. We want to talk about gifting corporate property, and the idea is, and we talked a little bit in the past, but let's make sure we walk through this very carefully, because gifting property owned by a corporation has in it its own unique elements to it, and the Court of Appeal has recently spoken about it, and there's some sort of fundamental decisions on this, all of which is available. All of the sites are available on our webpage under Solicitor's Tip, an article that Susanna wrote. But today I want to just talk about some of the general concepts, because bequests of corporate property have failed in certain jurisdictions and other provinces on the basis that the testator cannot gift property that they don't own personally. And it started out in a decision back in 2012. It was a Mayor and Rose case from Alberta Queen's Bench, where gift of corporate property may have been valid in Ontario, but it wasn't found to be valid in that decision, and started to get everyone quite nervous, and it has generated some real case law over the last 10 years. The courts will honor gifts of corporate property when the testator is the sole shareholder of the corporation holding the gifted property, or the testator is the only person who can control the property through the corporation. So some of us remember the classic case, the negligence case of Earl and Wilhelm, and it was a case from the Court of Appeal in Saskatchewan, where the court held the lawyer was negligent for having not properly gifted corporate property and not having identified the true ownership of the property, and the lawyer paid the price of not focusing on that. I don't know, Susanna, are you back in?
I'm back
Maybe
in.
not. Okay. You seem to be fine.
Oh, so you can hear me?
Yep.
My apologies, everyone. I'm having technical difficulties here, but yes, I'm back on. And certainly heard your introduction there with the Earl and Wilhelm decision, and how, for the longest time, we always told clients that we had to really delve into who owns the actual asset that they want to gift away, and how you can't necessarily gift away corporate assets in your will without, having done some special planning. But I think estate planners will certainly want to be aware of the risk that, a gift of corporate assets can still fail, even if we're meeting some of these tests that are set out in the recent cases. For example, we've got a gift that may not be honored in a circumstance where the testator only has a partial interest in the corporation. I know, Ian, you said as long as they control the corporation, they might be able to gift it. But if they don't have a full interest in the corporation, then that might be an impediment to being able to gift something in their will. And the gift of corporate property can also fail if the testator is not the sole shareholder of the corporation. So if they don't have the actual authority to direct the company, that might also be create difficulties in trying to give something that's held by a corporation in your will.
So knowing of these concerns, and it obviously makes good sense to determine this. What, as a solicitor, then, what are some of the steps we want to take to collect the information about the client's corporate interests?
I think we always start with our checklists in the sense of really trying to delve into, we call it probing and verifying what assets are owned by the testator and how, if there is a corporation, what is the structure of that corporation? Who are the shareholders? Who are the directors? What are the assets that are held by that corporation? I think that's really the first starting point in terms of delving into ownership and then ultimately authority to deal with those assets.
And of course, checking in with the client as to whether or not there's shareholders agreements in existence is crucial in terms of analyzing the ability to give away corporate assets.
That's right. And just, I guess, to clarify for the purposes of our discussion today, we're actually talking about the actual corporate assets, things that the corporation owns, as opposed to the corporate shares. That's a very different form of planning where, you see that all the time when we're dealing with these situations. And so when we're talking about these situations, we're talking specifically about assets that we don't personally own as testators, but that are owned by corporations that we have an interest in.
Okay, Susanna, so then what are some specific questions you want to ask the client at the intake stage regarding the corporations?
I'm going to want to understand what is the property that's held by the corporation. What are its assets? Is there real estate? Are there investments? Are there bank accounts? I want to make sure that I've got a good understanding of what it is that is actually owned by the corporation. And then I turn to how is it that the client wants to dispose of that property after death? So those are the first starting points. Followed by then, is there anyone else who might have a say in terms of how the corporation is actually controlled? So that comes down to that sole shareholder or the ultimate director who might be able to make these decisions on behalf of the corporation. And then finally, I like to explore with my clients whether or not they want to consider dissolving the company upon their death, as opposed to having it continue on as a going concern, perhaps.
Okay, so then as a will drafting tip for corporate property, we learned a little bit from the Trezzi decision from the Court of Appeal, and that's the Court of Appeal decision of Trezzi versus Trezzi. It was a 2019 decision that came out 2019 on CA 978. Here we are. Thanks, Jordy. There's the site. Susanna, can you tell us a little bit about where a client wishes to gift property and some of the things we learned from the Trezzi decision?
Yeah, I think it helps to sort of know a little bit about the facts here. They're not very complicated. We had a deceased who was the sole shareholder of a corporation, the Trezzi Construction Company. And in his will, he wanted to give certain assets that were owned by the corporation to certain beneficiaries. So he wanted to give, for instance, his real estate and investment property to one child and the rest of the assets to his spouse and other children. And so when it came down to, trying to administer the estate, the wife and the other children challenged the gifting on the basis that the deceased did not actually own it. And they tried to focus on, corporate law principles and the fact that, a corporation is a separate legal entity from the testator, him or herself. And so at first instance, the application judge looked at the surrounding circumstances to try to determine the deceased's intent. He also looked to the provisions of the will that ultimately concluded that the deceased could bequeath the gifts that were held by Trezzi Construction to his son. And then on appeal, that decision was upheld. So the court delved into, what was that intention evidence? What was really, going on here? Was there anyone else who had control or would be able to control those assets, and ultimately found in favor of, upholding those gifts, which was, a real shock to those of us who had been governed by, the Earl and Wilhelm kind of decision for years prior to that.
So Susanna, in Trezzi, and I think it's found at paragraph 23 of the decision, the court endorses a specific will clause language. And I'm just wondering, first of all, your thoughts on that, and maybe we can just talk about what that endorsement was.
Yeah, I'm actually looking, I don't have this case right in front of me, Ian. I know Jordy's
No,
pulling it up.
yeah, it's where the court ought to expressly identified that they ought to expressly authorize the estate trustees to handle the corporate assets. And
Yes.
in Trezzy, and in that case, the Court of Appeal endorsed a specific will clause.
That's right.
And oh, see, there's Jordy's got it there, but it's also you've got it there too, I think.
Yeah.
The clause
So
I'm talking about.
Clause is generally, it provides that if at any time my trustees hold in my estate any investment in or in connection with any company or corporation, my trustees may join or take any action in connection with that investment or exercise any rights, powers, or privileges that at that time may exist or arise in connection with this investment to the same extent that I could if I were living in the sole owner of the investment. The court held that that language was sufficient authority for the estate trustee to be able to deal with the corporate assets and uphold ultimately gifts that were made in the will.
So Jordy, I know on the drafting side, it's probably wise to use broad language to describe a gift of corporate property in the client's will if the client wants to encompass a variety of types of shares other than or other types of property. So when we bequeath any interest, that kind of language, does that help us get over the hurdle when we want to make sure that we've caught everything?
Sure. I don't know who that there's still lots of noise, but so yeah, I mean, certainly if you're using eState, eState automatically checks for that kind of issue and puts in a clause directing that the trustees take the steps in order to have the corporation do what you've just told them to do. So if you're an eState user, it's less of a worry. You can also in any particular situation, if you're well aware that a corporation does own an asset that you're trying to deal with, if you want to be even more specific for that particular asset and say, I direct my trustees. Now, again, as you've said, you got to control the board. So if you're a minority shareholder or you're a 50% shareholder as the deceased, and you're trying to do something with an asset, that's not going to work, and it may not work, and that's why ownership is so important. And I really, one of the first things, because the clients don't assume that, they just say, oh, I have a property, and you say, well, who owns it? Oh, the corporation owns it. But that makes a huge difference if you're trying to deal with specific assets. And it's not an easy thing to deal with, and there are tax implications. You're rolling assets out of corporations. If it's a corporation that only owns one asset, well, that makes it a little bit easier. But often that's not the case, and so there are tax implications and others. So this is a reason to be extra cautious with gifts of specific assets.
Thank you.
Yes,
So, sorry, go ahead, Susanna.
I was simply going to just add, I think, when we're dealing with clients who have these privately held corporations or these small corporations, there's so much intermeddling between the private assets and their corporate assets that they almost forget, in a sense, and they probably do forget in many instances. And so the tax implications of dealing with these assets in a will, I think, is particularly important, and something that certainly we want to keep in mind when the clients are doing their planning.
And Susanna, there's a couple of cases that are worth just mentioning when the courts have tested this language. I know in Captain, they talked a bit about it, and the McDougall estate, and McDougall and Goodrum, both of which are in your solicitor's tips. Can you make some comment on that, and especially the Captain, with the kind of language that the court considered with regard to bequeathing, using the concept of the term any interest?
Sure, Ian. I think you alluded to that when you said, any interest that the client may have in the corporate property might be sufficient to deal with it. And the reality is it can be, but just like any, case before a judge, it could go two different ways. But in the captain decision, that kind of interest did work, or that language, sorry, did work. And, you know, that kind of drafting can also be appropriate if the client has an indirect interest in a property, or sorry, in multiple corporations. But as long as ultimately it comes down to them having control over, as Jordy said, the board, then we can trace it through those different layers to make sure that they still are the only ones who can deal with that. And in those cases, it may be that they can in fact gift corporate assets in their will.
And so, and then of course, the court looked at this question in McDougall and talked about language that worked there. Do you want to just give us some thoughts on that?
Yeah, in that situation, a gift of corporate property was found, the court said, it should not fail if the will authorizes the estate trustees to do whatever is necessary to transfer property held by the corporation to the beneficiary. So again, coming back to that control and that authority to be able to effect those transfers.
Susanna, you talked about dissolution on death as an option to talk to the client about. What did they deal with? How did they talk about that in Trezzi?
And the Trezzi decision, the court was pointing out the fact that, you know, you may want to expressly give your estate trustees the authority to wind up the corporation in the will. Although, you know, this power would normally devolve to the estate trust through corporate law anyways, but it was sort of a belt and suspenders thing that, you know, if you go that far as to actually say those words, it just makes it a little bit stronger.
Well, that's great. I apologize. I don't know why I've come in and out of this call. It might be me that's causing this background noise. I don't know. I'm on to two different devices, but anyway, I apologize if that is me, but I'm trying to figure it out. All right. So, Jordy, just before we move off of corporate gifting, we can cover one other gifting topic if we have time, but I just wanted to check back in with you because we have the special privilege of having you on this call. So I don't want to leave it without this topic without having your final thoughts or words.
Well, it's my pleasure. But I would just say this is what makes our job so much harder. Is if everything was just owned personally by the testator, it would be an easy job. The problem is all these moving parts, assets that are owned not by the testator personally, but owned by a corporation, by a trust, co-owned, jointly owned. You know, all these different, they make they're hugely important because of course the will only deals with things that the testator owns, not things that what the testator owns in some ways. So you got to be very careful in this, and ownership is so crucial. And that's why delving into assets, you know, are very important. Deep dives.
Well, thanks, Jordy. All right, we've got a couple minutes, and I just wanted to cover one other piece on gifting that comes up a lot in our practice, and both from a litigation standpoint and from a drafting standpoint, and that's gifting when a gifting occurs in the context of compensation. And I just thought, Susanna, we've got a couple minutes. Maybe we could just get your thoughts on that. When a gift to an estate trustee is put into a will, how does that marry up with issues of compensation?
So we know certainly that estate trustees are entitled to compensation. And when we have a will that provides either for that or also a legacy, we're looking at ultimately, I think the real question for the testator is the tax consequences of that. And, you know, we know compensation is taxable, but a bequest normally is not. And so when we're looking at drafting these situations and perhaps trying to avoid a taxable moment for the executor by calling something a bequest rather than compensation, that's when we rise and get into these situations where we know ultimately CRA is going to be looking at this and testing our interpretation of whether or not something is taxable. So that's where it arises in these situations. A gift to an executor in lieu of compensation or in addition to compensation becomes the real question ultimately in terms of intention.
And so what is the presumption that we have to work with on the gifting? It's presumed that can you hear? Sorry, probably my noise.
It's presumed that it's going to be a gift. And so, and so,
No, it's,
wait a second.
I think it's presumed to be a gift is presumed to gift when is a gift to an estate trustee presumed to be compensation is the question, right? And the presumption, so you say CRA is going to look at it. But where we have to be careful with is there, if there's a presumption, how can we rebut the presumption? So first of all, what's the presumption? And second of all, what can we do to rebut it?
Yes, that's right. It's all going to be based on the evidence and the intention and the ultimate drafting of it. Because if it's compensation, we know it's taxable. If it's a gift, it's not. If there's only a gift with no reference to compensation, then I think CRA is going to be looking at it a little bit more closely and trying to find it to be a taxable event. Whereas if there was both a gift and compensation, it's different. We all try to overcome the presumption by, of course, showing that it's either in addition to or that it's not meant to be on account of compensation. But the cases are definitely going to go both ways on these things, and it's really going to depend on how tight the drafting ultimately is.
And Jordy, how do you deal with this at the estate?
Well, because the presumption of a gift being a gift to a legacy to an executor, we have that presumption of it being in lieu of compensation. So what estate does, it sees that, is there a gift to a person who's also an estate trustee? If so, it puts in language that says this is in addition to and not in lieu of compensation. And so that's an easy one you can miss because it requires the corroboration of the data and the correlation of the data. So that's one thing that it does.
And it's an easy drafting fix.
Yeah. I'm sorry, Ian.
No, good. It is rare for sure, but it's an easy drafting fix if you put it in expressly that way.
Absolutely.
Okay, Jordy, I think on the chat, there's been a little bit of back and forth on the link for your Tuesday chats.
Yes.
So you want to clarify?
Yeah. You should be getting emails. I understand that some people are not getting emails about our Tuesday webinars. We will make sure that's publicized and you get the emails. We'll make sure if you're on eState, there'll be a note about that and how you sign up because you have to register. There's no charge, of course, but so we'll make sure we get that out to everybody because they're great courses and we have a great discussion. People raise different issues and it's a great way to learn because like any technology, it takes a little bit of time but it's well worth it in the end. So thanks for all of that and look forward to Tuesday's webinar.
Awesome. Well, thanks, Jordy. Thanks, Susanna. We'll be back next week with another riveting topic and hopefully technology will be a little bit more blessed.
Indeed. Thank you, everyone, and my apologies.
Thanks, gang.